Hey, good afternoon, everyone, and thank you for joining the Human Rights Lawyers Association, the Association of Law Teachers, and Exeter Law School for our seminar today, spotlighting creative and innovative approaches to human rights education in and beyond the University Law School. We have a packed programme for the day with a mix of keynotes, academic presentations, a panel discussion, and an in-person, in conversation with segment with legal academic and documentary filmmaker Dr Malcolm Rogge. The event has been designed to bring together human rights defenders from both academic and NGO settings to share, examine and reflect on new approaches to human rights education and training. And there's a real emphasis on collaboration and experimentation, practice-informed pedagogy. For those of you who aren't already familiar with HRLA and ALT, I just want to take a moment to introduce myself and the organisations involved as well. In today's event. So I'm Dr. Louise Loader. I'm a senior lecturer and director of employability at the University of Exeter Law School, vice chair of HRLA and a member of the executive committee for ALT. So I'm wearing several hats today. The Human Rights Lawyers Association is a forum for those involved in the law to discuss human rights issues. We aim to increase knowledge and understanding of human rights, aiding their effective implementation as well within the UK legal framework and the system of government. So furthering research, education and training in the areas of human rights law and practice. The Association of Law Teachers, it's a community of academics, professionals and practitioners engaged in legal education. Members support legal learning in schools, colleges, universities and the professional sectors as well. We aim to inspire and celebrate excellence in law teaching and really share the understanding and practice of legal learning. So I'm going to hand over now to Fionn Riley, HRLA EC member and barrister at number 5 Chambers, to tell us a little about our speakers and our sessions for today.
Thank you, Louise. In the first part of our seminar today, we're going to welcome leading academics who'll be presenting creative, innovative approaches to human rights education in the university law schools. And they're going to be representing the universities of Exeter, Bedfordshire and Bristol, Cardiff University and City St George's. I'm pleased to be chairing the academic presentation segment with Louise, and I'll be back a little later in the day chairing the In Conversation with segment with Dr. Malcolm Rogge, who's made an impactful documentary film called The Tribunal. If you haven't watched it and would like to, the film is on our website, the HRLA website, on the event page, and that comes after a panel discussion, which I'll hand over to Vicky to tell you more about. Over to you, Vicky.
Thank you. Hello, I'm Vicky Praise, and I'm also a member of the HRLA Executive Committee. And this afternoon, I will be chairing a panel discussion as part of today's seminar on human rights education beyond the law school. And we will be welcoming Friso Roscombe-Abbing, who is the Director's Advisor on Communication and Head of the Brussels Liaison Office for the EU Fundamental Rights Agency. My dear friend and colleague Robert Fellner, who is the founder and the CEO of humanrightscareers.com. Samantha Knights, KC, who is a barrister at Matrix Chambers, and Sabrina Matani, who is the co-founder of Women Beyond Walls. Thank you.
Thank you, Vicky. Thank you, Fionn. It's a real pleasure now to introduce our first opening keynote speaker, Yasmin Batliwala, MBE. She's the CEO of Advocates for International Development. Yasmin has held a number of significant leadership positions over the years within the public and third sectors in HIV/AIDS, drug and alcohol dependency and criminal justice, undertaking work for the UN Office of Drugs and Crime. Yasmin has considerable board-level experience, including having been on the board of a large NHS trust. She was the governor of the University of Hertfordshire, and she's also served as a magistrate in the youth and adult courts. Yasmin was a recipient of the City of London Woman of Achievement Awards, and in 2022 she received an MBE for her work in human rights, rule of law and international development in the Queen's New Year's Honours List. And in July 2025 she was awarded an honorary doctorate in law by the University of Exeter in recognition of her work and unwavering belief in the law as a force for justice, dignity and global progress. Yasmin, over to you. The floor is yours.
Thank you very much, Louise. A very good afternoon to you all. I'm really delighted to be with you to speak about a challenge that is perhaps as urgent as it is full of possibility. And that, of course, is bridging the gap between our universities and our NGOs in the vital work of human rights education. Let me start by saying this is not really an abstract challenge. It's about how we train, inspire, and equip the next generation to defend human dignity. It's about how we ensure that academic excellence meets real-world necessity. It's about how ideas are forged in the classroom and how they're tested, as well as sharpened in the places where human rights are most under threat. And it's about overcoming a paradox that perhaps two of the most powerful forces for human rights, that is universities and NGOs, often stand side by side, working towards the same goals, but without truly working together. At the heart of human rights lies the conviction that knowledge must serve justice, that learning must translate into change, and that theory must guide practice in ways that alter the course of lives. And yet, too often, the academic and NGO worlds operate in parallel rather than in partnership. Both are rich in expertise, both are committed to justice, but separated by structures, cultures, and expectations. Let's then consider what each brings to the table. Universities are the engines of critical thought, rigorous research, and disciplined analysis. They cultivate future lawyers, advocates, policymakers, and scholars. They preserve the principles of open inquiry and evidence-based argument. NGOs, on the other hand, live in the world of urgency. They are, if you like, the boots on the ground. They fight injustice as it unfolds. They know the pulse of communities, the reality of oppressive systems, and the day-to-day resilience required to keep going. Each has strengths the other needs. But too often they work in silos, like ships passing through the night. But why? Because their operating systems are different. Academic calendars versus project deadlines, reward structures that value publications versus those that value measurable social impact, different languages, one that's steeped in theory, the other in the immediacy of lived experience. When we fail to translate between these worlds, we lose something vital. Students lose opportunities to test their learning in the real world. NGOs lose access to rigorous research and fresh ideas. And the human rights movement loses the creative solutions, the innovation, research, and energy that only true collaboration can bring. At Advocates for International Development, or A4ID, we believe that law is not just a profession, but a tool for social change. We exist to bridge precisely these kinds of gaps. We bring together the legal profession and development organizations to use the law as an effective development tool in tackling global poverty and injustice. Our Role UK programme, which stands for the Rule of Law Expertise UK, connects legal expertise with organisations that need it most. It's not charity, it's partnership, pure and simple. We work with UK-based lawyers and academics and pair them with NGOs, bar associations, and governments across the global south. We have seen that when an academic knowledge meets grassroots reality, the results can be extraordinary. These partnerships have shaped real-world outcomes and enriched academic work. Because when academics are exposed to the complexity of the field, their research questions sharpen, their assumptions shift, and their teaching gains authenticity. What we've learned is simple and perhaps yet profound. When knowledge and action meet, change accelerates. When a law professor in London works with a women's rights NGO in East Africa to analyze draft legislation. Both sides grow stronger. The NGO gains the depth of expertise, and the academic gains the insight of practical realities. And the law that emerges is better for it. Despite these successes, we cannot ignore the fact that universities and NGOs' divide is still wide. The obstacles are not always about willingness. There is, after all, goodwill on both sides. They are, as I said, about systems. Firstly, different timelines. Academic years and research cycles rarely match the immediacy of NGO deadlines. Secondly, different incentives. Universities reward publications and citations. NGOs reward impact and outcomes. And thirdly, different measures of success. For a university, success might be a peer-reviewed article. For an NGO, it's a change in law, or a community that feels empowered to claim its rights. If we do not actively address these misalignments, we risk leaving human rights theory in lecture halls and human rights practice without the benefit of cutting-edge scholarship. But I believe we can imagine something better, a world where human rights education is co-created between universities and NGOs from the very beginning, right from the very onset. A world where students don't just study human rights, they live it, test it, refine it, and do so in real time. A world where NGOs don't just receive expertise, they shape the questions, challenge the assumptions, and guide the research that matters most. So here's my invitation, or perhaps should I say my challenge to each of us. To universities, build structures that make collaboration with NGOs part of your core mission. Value impact as much as publication. Reward academics who take their research into the field and students who apply their learning in service to others. To NGOs, welcome the deep, sometimes slow but always valuable engagement that universities can bring. Shape research questions with academics. Mentor students, not just in human rights law, but in the law of human realities in terms of human rights work. To funders and policymakers, invest in these partnerships. Sustainable funding, flexible timelines, and recognition of co-created outputs are obviously essential. And to students and young professionals, be the bridge yourselves. Demand opportunities that connect you with real-world human rights challenges. Push your institutions to think beyond the classroom. Bridging the university and NGO gap in human rights education is not a nice to have. It's a necessity, because the stakes are not abstract. They're measured in lives, in freedoms, and in futures. At A4ID and through our Roll UK programme, we will continue to bridge these gaps and build these bridges, because we unite knowledge and action. And when we connect research with reality, when we blend the energy of youth with the wisdom of experience, we create something unstoppable, a global movement for justice that no gap can divide. So let's close the gap. Let's teach human rights, not only in theory, but in partnership. And let us make sure that the next generation inherits not a body of knowledge, but the tools, the networks, and the courage to make it work. Let's not just teach human rights, let's live them together. Because together we can build a future where the law is not just studied, but lived, not just taught, but practiced, not just debated, but used as a tool for hope, for dignity, and for justice. Thank you.
Thank you, Yasmin, for sharing your insights, which were hugely inspiring and lots of food for thought there. I'm delighted now to introduce Ben Leather, who is the Director of Peace Brigades International UK. Ben's human rights career began in 2008 as a field volunteer with PBI Mexico before leading the organisation's advocacy work in country. At the International Service for Human Rights, he lobbied alongside activists from around the world for human rights defender protection, corporate accountability, and a stronger UN. Ben then went on to work for Global Witness, where he investigated abuses linked to natural resource exploitation and campaigned on human rights and environmental issues. Most recently, he worked at Camara, training NGOs in risk management and leading investigations into the perpetrators of attacks on social justice leaders. As a consultant, he has provided training on security, advocacy, and strategic engagement with international human rights mechanisms. Ben, the floor is yours.
Thank you, Vicky. Can you all hear me okay? Glad to know that. Thanks a lot for the invitation to speak. I think I'd start just with a little reminder of what PBI is, what Peace Brigades International is. So we're an international NGO that for more than 40 years has provided protection and support to human rights defenders who face threats and reprisals because of their activism. So we work with a whole range of human rights defenders, from indigenous leaders defending their land to women who are mobilizing in their communities to stand up to police violence, and in many cases, student movements and activists in academia as well. And what all of these human rights defenders who we work with have in common is that unfortunately they face threats, they face physical attacks sometimes. Some of them have been criminalized, others have faced smears online, but they face a whole range of reprisals because of their work for human rights. And what PBI does is train up what we call protection volunteers or field volunteers from around the world who go to some of the places where these defenders face the greatest risk and work with them to keep them safe, alive and heard. Because that's at the core of our ethos, is that those local defenders and community movements must be heard if effective human rights and environmental change is to come about. The way in which we do that is what we call field volunteers or protection volunteers wear a uniform a bit like UN observers, and they're in the communities where human rights defenders are facing that backlash, and this deters attacks on those human rights activists. It only works, however, because of the analytical work that's done behind the scenes to understand these perpetrators of who want to do harm to human rights defenders, and to understand how we can change their behavior. And a lot of really important academic work has been done on understanding perpetrator behavior. Why do these people want to silence human rights activism, and how might their behavior be changed? We also do a lot of capacity building work, as I'll discuss afterwards. And so when I was asked to talk about bridging the university NGO gap in human rights education, the first thing that really came to my mind was PBI's work that our protection teams are doing around the world to protect human rights defenders and human rights movements in and around universities around the world. Because as we all know, I think whether the emblematic cases brought forward by law professors and students in the US as part of the civil rights movement, whether the student movements at the core of the anti-apartheid campaigns in South Africa, or the more recent student uprisings in Bangladesh, universities, students, and academia have long played a really crucial role in protesting for human rights and ensuring they're upheld. But in some places, that's a more dangerous thing to do than in others. And I want to take a moment just to acknowledge the awful news coming out of Nepal yesterday, where Gen Z protesters were shot and tortured by Nepali police as they protested the country's social media ban, but also widespread corruption in the country. At least 20 student activists were killed, and that shows the really real risks around the world for those who are standing up for rights and bringing activism into academia. And this isn't a movement that we've worked with, but our team in Nepal is now reaching out to them to find out how we can support. There are a lot of examples of where we do protect activists on campus, for example, in Mexico, where we work with a group called Comité Cerezo, and what they do is they document police violence, and they support political prisoners and disappeared activists, many of whom are students or are involved in student politics and activism. In Costa Rica, we work with exiled Nicaraguan human rights defenders. In 2018, the Nicaraguan government actually closed a lot of universities and refused to recognize the degrees of students who had been involved in activism and standing up for human rights. And PBI is working with the UK government to encourage them to help universities here to support the recognition of the students' credentials that are not recognized in their own country. So perhaps the clearest area where the gap's already bridged and where continued collaboration is as urgent and important as ever is in protest, is in activism, and is in solidarity for the protection of student human rights defenders, not just nationally, but globally. But where else can I see examples of where PBI bridges that gap? Firstly, it would be our protection volunteers. This is a lot of the people who go out to our PBI teams around the world and provide that protection to human rights activists, human rights defenders locally, have recently graduated. This was actually my case way back in 2008, very long time ago. I'd left university a couple of years previously, had already started to work in the UK, and then went to volunteer with PBI out in Mexico. And it was a life-changing experience. I always say, although some people may disagree with me on this in this conference, but I always say PBI is the best human rights school. A year out providing protection to local activists really provided me with tools that I hadn't gleaned in academia, but built upon the tools that I had, and set me off on the course that I've been on since, working professionally in human rights defense. And there's actually a recruitment window open at the moment for people to sign up and go to our teams either in Guatemala or Mexico and provide that frontline protection. And you can find more information on our website. Another thing that PBI does a lot of work of is capacity building, whether that's about how to build your own risk management capacity, whether it's in how to advocate for human rights change, or whether it's in how to keep your well-being and psychological well-being strong in the face of repression. This isn't something that we usually call human rights education, but you could, and that capacity building component, I think, is fundamental in a strong global human rights movement. And I think that there is more that we could do to work with human rights courses, universities and others to scale up that work and inform that capacity building work. And we're actually seeking funding at the moment to really systemize and scale up the tools that we've already pulled together for capacity building in safe and effective human rights activism. A lot of those tools are online, but if you're interested in accessing them and can't find them online, don't hesitate to reach out. I've talked a lot about where we do our direct protection work, but I'm head of PBI's UK office, and I'd like to quickly mention what we do in the UK. We don't do the protection work, but we do a lot of work to connect those human rights defenders around the world that we protect with support in the UK. We also help them to advocate with decision makers here and to raise funds for our protection work. Now, a big part of our work in the UK is our legal network, where we have lawyers, barristers, many of whom are academics who are part of our legal network, and they're on hand when we need them to take a range of actions, which could range from letters or statements when a human rights defender has been detained somewhere in the world, trial observation, other forms of pro bono support, the submission of amicus, capacity building. So a whole range of things that our legal network does to support human rights defenders at risk around the world. One of the things that we've done a lot of recently, and actually with the support of A4ID's Roll UK program, has been delegations of international legal experts to visit human rights defenders at risk around the world. And that's led to a range of changes in those countries, whether that's to do with the protection of those activists or changes to laws and policies in those countries to strengthen the rule of law there. So I'm sure there's a lot more that we could get out of in terms of our collaboration with students and with academics. And in the current polarized world, I think a big piece of that needs to be making the case for human rights and for those who defend them. Something that comes to mind that I think there is an information gap, for example, is demonstrating the real impact that human rights defenders have on the climate. We know that often Indigenous leaders are defending land that they farm sustainably in the face of, for example, oil companies or mining companies who want to do quite the opposite. And having an academic and empirical base of evidence to demonstrate the impact of those human rights defenders on defending our climate could help us to protect them more effectively. We have done a range of really useful studies together with academics, such as with the University of York and Amnesty International, where we pulled together evidence of how the UK can successfully support human rights defenders at risk. Two very final things to mention that we do with universities to promote human rights. One is with the University of Dundee, where we're on the board of the Scottish Human Rights Defenders Fellowship Programme that welcomes human rights defenders for respite and advocacy opportunities. I think that's something that we would like to see in other universities. There's also a programme at the University of York. And finally, we have a volunteer programme at Peace Brigades International's UK office. The next one will be advertised in November on our website, and that's an opportunity to come and work with us and get experience with PBI UK. So the best way to find about that and any other activities and campaigns we're doing is to sign up to our mailing list at bit.ly/PBI news.
Ben, thank you. Thank you both very much. Yasmin is about to leave us, and Ben, I know that you need to head off, but huge thanks to you both for being with us today and sharing your insights on how we can more effectively bridge that university NGO gap in human rights education. I've put some links in the chat to various programs and initiatives that A4ID and PBI UK run. So the A4ID Roll UK program and the excellent legal guide to the SDGs, which I've included in the first year legal foundations module that I convene at Exeter, and our reading list for the topic week on law and the SDGs for several years now. I've also put some links to PBI's website for general information on their programs and their work in the UK and internationally, as well as a link to the volunteer opportunities at PBI. Thank you again, Ben. Thank you, Yasmin. We come now to the academic presentations part of the programme, and we're welcoming speakers from several universities to share some great practice and innovative pedagogies for human rights teaching in higher education. We'll have around 10 minutes for each talk and then some good time afterwards for Q&A from our audience. So please do feel free to put your questions for our speakers into the Q&A box, and we'll get to as many of these as possible in the time that we have. And Fionn is now going to introduce our first speaker in this segment.
Thank you, Louise. It's my pleasure to introduce Rachel Murray, and she is Professor of International Human Rights Law at the University of Bristol and Director of its Human Rights Implementation Centre. Rachel undertakes regular work on the African human rights system, implementation of human rights law and torture prevention, among other areas. She's written widely in these areas and advises and works with national, regional, and international organisations, including the African Commission and Court on Human and People's Rights. She's currently a Fellow of the Human Rights Centre at the University of Essex. She is Global Distinguished Professor of Law at the Notre Dame London Law Programme, Visiting Professor at the University of Oxford, and Deputy Leader of Doughty Street Chambers International Team. And she's also, in her spare time, a magistrate sitting in Bristol. Rachel, thank you so much for joining us, and over to you.
Thank you. Can you hear me okay? I hope you can't hear my dog in the background that's just suddenly chosen this moment to start barking. I'm going to share my screen with you. Hopefully you'll be able to see this. Can you see that okay? See if
yes, that can be seen, yes.
Yeah, okay, great. Thank you so much for the invitation to this really important event. I'm going to start by giving you a little bit of background to my own work, because I think this helps understand how I've then involved students in that and the opportunities I've given to students. And then I'm going to talk a little bit about the Human Rights Law Clinic that I set up at the University of Bristol, and then some of the sort of issues and challenges and opportunities that presents when trying to do this type of sort of practice-led engagement for students. So I very much don't see academic research as distinct from practice or from teaching or opportunities or engagements that students acquire. As Fionn mentioned, I've got sort of 3 strands, I guess, to my work at the moment. Firstly, it's around monitoring places of detention or deprivation of liberty under the UN Convention Against Torture's optional protocol, which is around sort of setting up independent bodies to go out to places of deprivation of liberty in order to prevent torture or other ill treatment. And I've had recent projects with the UK, MPM in South Africa, and also recently with the overseas territories of the UK, and I'll come back to that. The second area is around implementation of human rights decisions. This was a large grant with the ESRC a few years back, and the aim here was to look at decisions and judgments that come out of supranational bodies, whether that's the European Court of Human Rights or the African Commissional Court of Human and People's Rights, where they order compensation to be awarded, legislation to be amended, etc., and then to see whether actually governments have done that. Have they given compensation to the victims and so on, and lots of the challenges around that. And then the last sort of long-standing interest I have is in the African human rights system. So with the African Commission and Court on Human and People's Rights, I've been attending the sessions of the Commission since the mid-90s and acquired observer status for the Human Rights Implementation Centre with the Commission, which means that it has an opportunity to make statements. My aim is very much to work with partner organisations, so I focus less on the sort of academic outputs, that comes a little bit later, and much more on the practice side. And I very much want to involve students in my work. When I started this in the sort of mid-90s, human rights were not really talked about. It was civil liberties, and the opportunities for sort of hands-on engagement was pretty limited. My work now is I am involved in litigation before international bodies, have a current amicus before the African Court. I've worked with the judiciary in sort of designing courses, and as was mentioned, I'm also a magistrate and regularly work with governments and NGOs, national human rights institutions, and I want students to be part of this. So I'm going to talk a little bit about the Human Rights Law Clinic, which is one of the key ways I try to do this. We set this up about 15 years ago, and what it does is it puts students into teams of around 10 students each, led by a student team leader and then overseen by a member of staff. And the role of those groups is to provide background research for external organisations who can be NGOs, they can be lawyers, they can be international organisations. Some of the examples of recent things that we've done. So last year, I've been working with the governor of a prison in the Turks and Caicos Islands who wants to take a human rights-based approach to all of the policies in the prison, whether that's issues around restraint, training, education, behaviour, etc. And so this was providing students, you train them up on the Mandela rules, and then they looked through the policies that the prison governor had drafted and give sort of feedback on the extent to which those were sort of human rights compliant. Another project was to map private companies' involvement in prisons in the UK and South Africa. And this is work that I've been doing with Professor Michael Addo at Notre Dame. We have been following up implementation of decisions by the African Commission and some of the UN bodies, looking at the extent to which governments have complied with those decisions, and then feeding that information back to the international bodies so that they can engage with the state and parties concerned. And then we've also been giving the African Court had an interesting project on wanting to see the extent to which media in its broadest sense referenced its decisions and its work. And I'll come back to that shortly. So we've had a project this year and various other things over the years around engaging with bodies like the Law Society, with human rights bodies and others in giving background research to litigation and work that they've been doing. So I think there are a number of things that are worth bearing in mind when trying to embed practice in teaching and engagement by students. Firstly, I think is the question, what are we trying to achieve with human rights education? And I think one of the things here is what you might learn in a traditional university setting in terms of human rights standards and the processes, how that actually applies in real life. And I think Yasmin said it brilliantly earlier on, academic excellence meets real world necessity. And I think one of the things that comes out of doing this work is showing the nuance of human rights, that sometimes it's not that straightforward. It's often not a binary state versus NGO approach. And, you know, human rights is incredibly polarized at the moment. And I think this type of work, you can see the subtleties of it. You can see where there's real attempts to move the human rights agenda forward. And I think that's quite important in the current climate. I think who to work with is really important. I've tried to ensure a breadth of human rights organizations, of various different types of organizations, and particularly in the global South and Africa, which is where a lot of my work has been. I think it's not always about picking the most obvious or the usual suspects or those that are perceived to be the most prestigious, but working with those who need it. So we worked with a small group of Cameroonian lawyers in a small city in Cameroon a few years back. I think a really important question is whose project is this? I very much see this as it being the project of the partner organization that we work with or whoever we're working with. And I think that's really important for students to understand that this has to be equitable. It has to be led by their needs and what they want, by the partner organization's needs and what they want, not what I might think might be important or what the students might think might be important at that particular moment. And you know, that can lead to frustrations on the part of students engaging with these types of projects, because I think, as Yasmin said, it doesn't necessarily fit with academic timescales. Things can start very quickly and then go slow, and so on. So there's a real need to be nimble. And that means as somebody supervising those projects, sometimes you have to pick up the slack, depending on the time frame and so on. Some of our projects have been confidential. So the partner organization has said, you know, we don't want this to be known. Students often find that very exciting, but then also frustrating, because it means you can't say anything in detail about it on your CV, even though they may have done some very interesting work. And this has to be handled very carefully, but the wishes of the partner organization are always the paramount in this context. I think there is a challenge of trying to ensure as many students as possible are involved in these opportunities whilst balancing varying levels of knowledge. So in our human rights law clinic, we take students from the second year of an undergraduate degree who may have very little or only just starting out on developing sort of human rights knowledge. And so then you have to tailor the tasks for the particular students, balanced against the needs of the organisation that you're engaging with. I think one thing that often comes out of this is the opportunity, space and creativity for student ideas. So students often will come up with some really fascinating ways of approaching things. And some of the projects we've done have been sort of pilot projects where we're working with the partner organisation who wants to know how they might go about doing something. So the African Court media engagement one that I mentioned is really interesting because they are sort of trialling how they capture information on what the media have said about their judgments and decisions. And the one of the students that has been working on this project, Tope Odude, has come up with this amazing sophisticated spreadsheet with the African Court, which she designed completely from scratch. So I think that, again, that space for students to develop, to have some creativity in the project, not always feasible, but where it can take place, it's really helpful. Regular and ongoing monitoring is really important in order to ensure that you balance what is the student's own work with a quality, robust and professional output that meets the demands of the partner organisation. So that requires sort of careful checking, monitoring. You know, this is quite time heavy in terms of ensuring that the partner organisation gets what they wanted. And finally, you know, I think one of the frustrations here is that students may not always see the results of their labours. Their input might be part of a much bigger project that the partner organisation is working on. That might only come to fruition, you know, months, maybe even years later, or maybe not at all. And I think that's, I mean, it's one of the realities of engaging in this work, but it's also one of the frustrations that I think students can feel. So I'm going to stop there. I hope I've not gone over my 10 minutes. Just to let you know, I'm moving to the Bonavero Institute of Human Rights at the University of Oxford from the beginning of October, where I'll be the director. The Human Rights Implementation Centre at Bristol will continue under my colleagues, Dr. Allinson and Dr. Biggio, but I hope that I very much will continue this approach in my time at Oxford, so I'm very open to opportunities to discuss further. Thank you very much.
Thank you. Thank you very much, Rachel. I think we haven't really got time for questions because we've only got 2 minutes until the next speaker. But would you have any tips for law schools who are starting out with a human rights clinic in this 1.5 minutes before the next speaker? I think that would be very helpful into where to start and how to find them. And I'll describe them as clients or partners to work with.
Yeah, I mean, I guess I've always worked on the basis of building on existing relationships. I think that makes it easier. Sometimes people will approach you and ask, and that's great. But I think building on people that you already know, they trust you, you trust them. You can have an honest sort of discussion about what's useful for their perspective. And as I said, it has to be very much led by the organisation that you're working with. I think that can be a very useful way of starting something if there's nothing there already.
Thank you. And what challenges and opportunities have you encountered in embedding the practice-led pedagogy that you describe, but within a university curriculum, which is firstly often structured around traditional assessments, obviously if these are full credit courses, and doctrinal content?
Yeah, I mean, so the Human Rights Law Clinic is an extracurricular thing. There was an opportunity to sort of have that actually in the curriculum, but actually students wanted to do something that was not connected, so something that they could put on their CV that was extra to the actual degree itself. I think, as I mentioned, you know, probably key challenges are timings. You know, you can try over the years to try and think, okay, this project will work, and the organisation that you're partnering with know that the students, there are going to be certain pinch times of the year where it's not going to be, they're not going to be 100% committed. So you try and adapt the project around that. But real life doesn't work like that. You know, deadlines get changed, suddenly something needs to be done imminently. So students often start off saying, well, how many hours a week am I going to be having to devote to this? And it's very, very difficult, because at certain times it's very busy and then it will go very quiet, or it might appear to be very exciting and then it will just stop. So I think there are managing expectations and time frames so that students have enough work to do, but at the same time, you have to be led by what the partner organisation needs.
Thank you. I mean, there's a question in the chat asking about readings for setting up law clinics. I don't know if you agree with me that the clinical legal education handbook that's available free, although it's a little bit older, is an excellent guide. I don't know if there's anything you would add to that as a starter, because it discusses very expressly university clinics.
Yeah, I mean, I think it depends, you know, there are a whole variety of different types of clinics. I think they, you know, from my probably limited understanding, they operate in quite different ways, particularly if you look internationally. And I think it, you know, just to go back to that initial response, I think it build on the expertise and links that are already in the institution that you're in, rather than necessarily thinking we have to have a clinic that looks exactly like this. I think there's huge scope for innovation and creativity in developing different types of models depending on who you're working with and what they need.
Thank you so much, Rachel. Thank you, and thank you, Fionn, as well for moderating that segment. Thank you very much, Rachel. I'm going to introduce Dr. Kerr Smith, lecturer in law from Cardiff University School of Law and Politics. Kerr is an interdisciplinary legal researcher who employs socio-legal research methodologies to explore problems of environmental law and procedural environmental justice. Her recent work looks at public participation in environmental decision making and at the Wellbeing of Future Generations Act, Wales 2015. She's a trustee of the SLSA, a board member of the Centre for Law and Society at Cardiff, and a member of the editorial board for the Journal of Law and Society. She's also co-convener of the Human Rights Law module in Cardiff. So, Kerr, over to you.
Great. Thank you so much for inviting me to speak at this event. It's a fascinating event. And apologies if you hear a bit of external noise. We are preparing for the start of the academic year with a lot of estates work here at Cardiff. I'm going to take a slightly different approach in my talk, and I'm going to talk about a study that I'll be running in my human rights law class this coming semester around discussing controversial issues. I'll look at the need underpinning this study and the kind of problem of supporting students to talk about these controversial issues respectfully and critically. I just realized I need to get my presentation up, so apologies, I'll do that first.
No worries, take your time.
Can you see that okay?
You can, yeah, brilliant.
Great. Okay. So looking at some of the problems of supporting students in this area and reflecting on some of the possible approaches that are available to us when we teach these controversial issues, or just kind of supporting students in discussing them. One of the concepts I'm going to particularly look at is a safe space. Lastly, I'll discuss the study I'm running in the semester in human rights law. It'd be really helpful to hear people's sort of feedback or thoughts on this pedagogic issue and on this study. So firstly, kind of a word on terms. What do I mean by controversial issue? I'm drawing on descriptions by Flenser and van der Lippe, and take controversial issues to be questions that are divisive, that involve different value systems and interests and perspectives, where it can be difficult to reach a consensus. It might be difficult to predict what issues will be controversial in any given classroom because it's going to be specific to the knowledge and values of the students that make up that classroom. But we can see that human rights law is going to be full of these kinds of issues. And we can see that our public sphere provides our students in our present society with lots of examples of people debating controversial issues, but not necessarily doing it in ways that we would like our students to replicate. Our public debate has become very fractured, divisive, polarized, and disrespectful, to put it pretty mildly. So it can be really difficult for teachers to leave space in their classes for these discussions. It can feel very risky as a teacher to open up these debates. It can feel like it might be upsetting for the student or for the teacher. It might leave the teacher open to complaint or the kind of thing that might be seen as a kind of a reputational risk for a school. And considering the extreme workloads that we are under at the minute in the academy, it might feel a lot easier just to kind of manage and kind of limit off and sideline these discussions. But really, these discussions should be at the heart of what we do in the university. This is the space where students can learn how to have these debates in ways that are productive and respectful. And it's an important part of our role as educators to foster democratic citizens. And part of this is encouraging students to engage in controversial, politically charged issues and linking with what we've heard from our previous speakers. If we are having kind of students are engaging in kind of really valuable real world experiences, these challenging conversations and being able to negotiate these challenging conversations are going to be embedded in that, will be part of it. And we might worry that the divisions we see in society are replicated in our classrooms, and I'm sure that they are. And as a result, that we'll have to manage these very heated arguments. But the reality is open conflict is quite rare. And actually the challenge is more in encouraging our students to speak openly at all on these issues and to not let their fear of saying the wrong thing, whether that would be factually or kind of ethically wrong, to stop them from saying anything at all. So in reading about how to best facilitate and support students in discussing controversial issues, the term safe space comes up a lot. And I think there's some very interesting kind of ambiguities and problems with this term that flag up more general kind of problems and things to think about in the tools we have to support our students in these discussions. So the term originally derives from the women's movement and LGBT movements of the 1970s. It's the term safe space is supposed to represent a space where marginalized people can be safe from discrimination, threat, and harassment. But when the term transfers into the university classroom, its meaning shifts. And it's generally understood to mean a space where students can speak freely and where students feel safe and respected by the teacher and by their peers. And Flensler and van der Lippe provide a very kind of insightful critique of this concept, and they highlight a paradox, which I've highlighted on the screen, that you might have noticed in my description. So on one hand, safe spaces need to be open enough to include all kinds of perspectives and positions coming from the students. But on the other hand, this openness needs to be structured by certain rules to which everyone can agree in order to make the exchange of ideas safe for both students and teachers. So in the safe space, there will be these conflicts that have to be managed. So not only do teachers have to kind of create and facilitate this safe space and need to negotiate these likely tensions or conflicts, they also need to be aware of the limits of the safe space that they can provide. Some of our students are not safe in our present society, and it is perhaps more dangerous to promise a safe space which we can only partially deliver in the classroom, and that disappears as soon as the students go through the classroom doors. Lastly, teachers should be mindful of the different understandings of safe space that might exist. Iverson notes that students and teachers might have different understandings of this term, and students might expect intellectual safety, as he terms it, not to feel challenged in their beliefs or opinions, but this is far from what teachers expect from classrooms. So Iverson suggests some other terms like brave space or classroom of disagreement or classroom civility that might do a better job of describing the respectful but challenging environment that we hope to provide for our students. So finally, moving on to the study itself, which, yes, I'm looking forward to embarking on doing it this semester. I'm yet to do it. So I'll be undertaking this study in this first semester of the year. It'll explore how students feel talking about controversial issues and about its place in their university education. It's guided by the research questions, which are up on the screen. So the first three are student-focused. What do students think about discussing controversial issues? What might help them to discuss controversial issues, and what inhibits them in discussing controversial issues? The fourth question, what makes it difficult to teach controversial issues, isn't a focus of the study, but something that I think will be kind of in an indirect, hopefully kind of output of the study, and something that I think future research will look more at, how we can teach and support controversial students in talking about controversial issues. The study will take a multi-pronged qualitative approach consisting of surveys handed out in the first and last lecture of the semester, results from a Mentimeter poll on the term safe space in the first lecture, and observation of lectures and seminars throughout the semester. There will be 3 forms of intervention over the course of the semester that will focus on observations and that we might expect to result in changes in students' perspectives on talking about controversial issues. In the first lecture, we'll explore the value of talking about controversial issues and the challenges it raises, and this will include a discussion of safe spaces. By exploring the kind of aims, risks, and unintended consequences of term safe space, we hope to encourage students to reflect on what the classroom can realistically provide and what will help them to feel comfortable to express opinions in class. And we hope this kind of really conscious focus on talking about controversial issues and kind of really underlining that it's an expectation of the human rights law class will kind of help students to understand some of the potential risks and also the values in expressing their opinions. In the first seminar, students will be asked to develop ground rules for their seminar group for the rest of the year. And this kind of hope to get into kind of to give a good bit of space to in the first seminar and really get into some of the detail, like what does respectful listening look like? What are the kind of practical rules and tips that we can have there to enable students to kind of feel safe to share their opinions? And lastly, talking about controversial issues is an inevitable part of the human rights law class, as I noted. Students will have multiple opportunities throughout the semester to discuss controversial topics. We feel that consistent opportunities to practice are essential to improving students' capacity to have these challenging discussions. So the main aim of this study is to develop understanding of what helps students to discuss controversial issues, with the aim that this will then support students who encounter controversial issues in their teaching and feel better able to not manage these discussions out, but really kind of sit with them and support students in having them. And hopefully to disseminate the findings of these studies in a kind of teaching-focused publication, and ideally to look at kind of maybe some teacher-focused training to support teachers here, as I think it's something that it's challenging for us to find the time to do with our heavy workloads, but as I said, it's essential to good human rights law teaching, I think. So thank you very much for listening. I'm happy to take any questions.
Thank you so much, Care. Really, really interesting and insightful there. I have a question actually about one of your research questions. So what makes it difficult to teach controversial issues? And I've been thinking about this a lot recently. I think very often as teachers, we might be inclined to avoid anything too controversial. So how do we move past that? What are some of the steps that a human rights educator might take to move past that first barrier, that hesitance to teach or talk about controversial subjects?
It's a really good question. I think I think some of it, just thinking anecdotally of about times where it's been challenging among colleagues to really teach on controversial issues. Being a little bit aware, prepared that it might come up, where it's come up kind of by surprise or kind of unexpectedly. I think it's been more challenging for teachers to teach on it because they've not kind of thought through how to manage this. That's always not going to be possible, of course. And these were, I think, maybe these, so the interventions I mentioned, right, it's kind of ground rules, it's hardly wildly experimental. It's something that we are used to as teachers, but I think it's devoting that really dedicated time to it. This is something that is useful. I think will also help teachers if they're kind of preparing the ground, and if students and teachers know those parameters well, hopefully that will help teachers to teach these controversial issues. Hopefully that somewhat made sense.
Yeah, no, absolutely. Thank you. We've had a couple of questions in the chat here coming to the host and panelists. So Rachel, Professor Rachel Murray has just asked a question about how we consider how students might manage dealing with engaging with some upsetting issues which human rights often raise. And of course, this is a very topical area. We're starting to discuss more meaningfully the need for trauma-informed approaches in human rights education to avoid re-traumatization and secondary trauma when having these challenging conversations and when you're teaching very complex and sensitive or politically charged subjects. And just to link back to Rachel's question, I wonder if you can share some of the practical steps and the approaches that you take to create that safe space in your teaching environment.
Yes, I think acknowledging that across the human rights law module, we will be touching on things that will be distressing for students, and I suppose the thing is particularly distressing for some at particular times. So flagging that these subjects are the subjects that are going to be raised, and if they have a particular concern or issue, to be aware that that's kind of there in the module, and maybe to email with the team or chat to the team afterwards if they've got particular concerns is one way that we deal with it. So slightly kind of forewarning approach. To know as well, I guess, I think I think one of the issues or where these debates can get polarized or fraught is where there's a lack of trust. So kind of sort of stating at the start that, so if we have an image that's distressing, we will be careful not to do that in a way that's gratuitous, and any reading, any image that we do, anything that we talk about is not to shock or distress, but a genuine prompt to learn. So to kind of to say that from the start and say, like, kind of trust us a little bit and we'll trust you. There has to kind of to try to set that kind of environment for teachers and learners.
Thank you. Just as a second part to that question, very quickly, do you think there might be a bit of a gap in training and academic professional development around trauma-informed teaching in higher education?
Definitely. I think, yeah, I think that will be something that's, yeah, I think there is kind of a real possible challenge there. And I suppose some of that is going to emerge in focusing on this more closely in the semester.
Yeah, absolutely. Now, I'd be really interested to see the results of your study. There's just very quickly before we have to move on. There are a couple of questions in the chat which are linked. So I'm going to ask the second question. How do you determine which subjects are controversial and which aren't? Some teachers can find a topic that they shouldn't discuss, while others might find it interesting. So how does one decide which topics are controversial and which ones aren't?
It's a good question. So I suppose I had that kind of brief description of a controversial issue at the start, and it's sort of a topic that might be divisive, that is likely to kind of touch on closely held values, but part of the thing is we don't know what some students, some people will consider some things controversial and some people won't. So I think there are topics that will come up in the first semester in the human rights law module, issues around trans rights, issues around, so we teach on the European Convention of Human Rights. So when we teach the SAS France case around the burqa ban and the court's judgment on that, that's likely to touch on controversial topics. So there's some things that, because they are topics of polarized debate in the news, because they touch on strongly held views, values, they're topics that I think are likely to, where there might be kind of controversial debates, controversial issues, but we have to be kind of aware and awake to the fact that there will be controversial issues that maybe won't strike me from the start as being controversial. So being very careful of that as we teach.
Absolutely. Thank you. Thank you so much, Care. It's been really great to hear from you, and I hope you'll be able to stick around for the remainder of the session. But thank you very much. Theon, I'm going to hand over to you to introduce our next speaker.
Thank you very much, Louise.
Sorry to interrupt, Care. You might need to just stop sharing your screen. There we go.
Thank you very much. And it's my pleasure to introduce you to Dr. Cynthia Chisholm-Umeseleke, and she is an international human rights lawyer, independent expert, senior academic, and globally recognized leading voice on climate justice, gender equality, and sustainable development. So she serves as the president of the Global Human Rights Centre in London and founding director of the Centre for Sustainable Development, Energy Transitions and Climate Change at the University of Bedfordshire. And she's also currently vice chair of the UK Human Rights Lawyers Association. Alongside that, she's contributed extensively to United Nations mechanisms, including written and oral submissions to special rapporteurs, the UN working groups of experts, and the Office of the High Commissioner for Human Rights. She is also a dual qualified barrister and academic. She was named among the top 100 most influential people of African descent under 40, and she's going to speak with us about navigating two worlds, bridging academia, policy, and advocacy through UN engagements. Over to you.
Thank you so much. And thank you all for, can you hear me? Yes, I'm a bit under the weather, so I'm going to try to push through. Thank you all, and thank you, Louise, for the kind invitation. And I will share my screen now.
Okay, that's great. We can see the screen.
Okay. Give me 1 second. Okay, can you see the screen now?
Yes, the screen can be seen perfectly. Thank you.
Great. So today I'll be speaking on navigating two worlds. So how do I navigate my full-time role in academia and also my UN engagements? And how do I bring the lessons or the experience from the UN into the classroom? Now, in terms of my UN engagement practice, that spans across over 70 engagements and counting, and that includes conferences, forums, symposiums, and summits. And I also contribute extensively through written inputs and oral submissions to the UN Special Rapporteurs, Working Group of Experts, and the Office of the High Commission on Human Rights Mechanisms. And then obviously some UN consultation and policy paper contribution. I know we just finished the zero draft for the Food and Agriculture Organization. And some UN fellowships, recently putting myself forward for one on people of African descent. And then another way I engage with the United Nations is through chairing and serving as a collaborating partner and co-session organizer at UN forums. Most recently, the one coming up next being the United Nations Responsible Business and Human Rights Forum in Bangkok, Thailand, where I serve as a chair and collaborating partner on the session on fuels to fairness, gender migrant labor rights, and climate vulnerable agri-food systems. Now, I always am very strict with the way I engage with the UN, and what that means is I focus on my core areas of research, so where I publish. And those areas are in human rights approaches to climate change adaptation, climate vulnerable agri-food systems, gender equality and inclusion, of course, sustainable development pathways for rural communities. And you could see from my core teams that all these issues are interconnected. So when I engage, I'm looking for solutions that integrate justice and equity. And of course, the UN frameworks, they provide the platform to build those bridges between my research and teaching and advocacy. Now, how do I connect UN, my UN engagements and academic teaching practice? In practice and in my classroom, I bring in live cases or live case studies from my UN engagement. So for instance, I created and delivered the module LLM Transnational Human Rights and Climate Litigation. And within that module, LLM Transnational Human Rights and Climate Litigation, we looked at experiential learning. So I taught the students how to go through the UN processes, including how to walk through how the mechanisms works from an international diplomatic perspective. And then we looked at critical skills to navigate governance systems and how that would benefit and how that can serve as a benefit and exposure to real world policies. So we're looking at climate litigations cases as they come forward in real time. And also one of the key things we also discussed, I remember, was the Universal Periodic Review, which showed in real time how the UN mechanisms can help highlight real world policy and make some changes within certain nations. And of course, in my practice, I always say that universities serve as knowledge incubators for advocacies and praxis. And from that viewpoint, I created what we now have as the Advocacy and Social Action Development Training Program. And I think beginning of this year, that attracted over 300 applications from 24 countries. And what we did with the program, the training program, was to teach students the rudiments of UN mechanisms and how to translate knowledge to practical actions. And then also in my assessment and examinations, I bring in, I provide students with the opportunity to independently critique global XDG processes and looking at both LLM dissertation and PhD supervision, ensuring that their research is moving forward with the times. And what that means is that they can transform their research into advocacy and public discourse as well. And of course, my aim always in the classroom is to produce a generation of students that are trained as scholar practitioners, and they are not just passive learners. Now, and I always say that academia, I view my United Nations engagement as an extension of my practice in academia as well. And how that works is through my research, so ensuring that the data analysis and theoretical frameworks inform UN reports, like I said earlier, contributions to special rapporteur mandates and working groups. And United Nations always views academics as independent experts. And this is because we always bring credible perspectives that are not political or diplomatic. that are not driven by political or diplomatic agencies. Now, in also my research and publishing, it's important that I use those research findings and I convert them to policy briefs and written submissions and oral statements at UN forums. And then, like I mentioned, I gave an example of the transnational human rights and climate litigation, but that also goes to other courses that I teach as well, including international human rights law, to ensure that public international law as well, that we're embedding UN case studies on human rights monitoring processes into courses, and that students benefit from simulations of UN negotiations through internships and UN agencies. And I remember when we did, I took on the legal skills and practice course, and we did a UN simulation in one of the negotiation case studies that we used. And of course, they get an exposure to life advocacy projects, which we do in the training, the Advocacy and Social Action and Development Training Program. And like I always say, in building students or training students to become future leaders, they have to engage with the UN framework, and that helps build their skills to enter into careers in policymaking, diplomacy, and advocacy. Advocacy and activism and human rights defending is one of the core aspects of my practice as well. And what that does, how I connect that with both my UN engagement and academics, is by amplifying the voices of the marginalized people. And most times I look at rural women in rural communities. And obviously channel that through my evidence-based field work, and bringing that also into UN mechanisms. And obviously, agenda settings, universities can shape global debate if we all engage by submitting to our expert opinions and reports to the OHCHR, special rapporteurs and UN working groups. They're always usually an open call for inputs and submissions, and that's how we build that type of synergy. And academic advocacy often also leads to recognition in global governance and also, of course, policy change. And most times people are actually not aware that 98% of United Nations special rapporteurs appointments, special procedure appointments, are from academia. So in my case, nominated by the UN Consultative Group, recommended to the President of the Human Rights Council for as the final two candidates for 2 special rapporteur mandates. And I could say that when I was the final two, the other competing candidates were all professors from, one professor from American University and one from Spain. And so such recognitions of academias in the field validates the academia capacity to impact global governance. And recognition of academic contribution also highlights our human rights advocacy. It reinforces credibility of universities as partners and not just bystanders. And it demonstrates a pathway from classroom to global leadership. And I like also bringing back my experiences going through whether it's doing the written submission and pulling up the draft on screen for students to go through, giving it to them as an assessment brief, or just discussing what the process was in getting through both the nominations and recommendation process with the Human Rights Council. And they always find it quite intriguing, because then I'm not speaking to them about someone in the field. I'm saying to them, this is what I've done. And this is the policy draft that came out from the work I've done. And this is the published inputs from the special rapporteur. Now, the bridge function of academia, we have to look upwards link. So moving knowledge, local knowledge and grassroots evidence into international spaces. So bottom up. And downwards link, we're bringing global UN norms, recommendations, and framework into classrooms and policy discussions, so top down. And of course, universities can mediate between knowledge creation, policy designs, and societal change. Now, why should academia and UN operate in silos? Why should academia and the UN not operate in silos? Like I've run through in the thread for this presentation, academia generates research that contributes to REF, educates and trains our students as future leaders to work within either policy within the international framework or even NGOs. The UN shapes global norms, policies, strategies, and accountability frameworks. And of course, there's always a shared goal between both, which should point towards inclusive, sustainable, and rights-based futures. There should be a synergy, like I always say, I always agree. And knowledge without policy influence, risk irrelevant. Policy without academic grounding risks weak legitimacy. Now, the two words, once they synergize, they can strengthen both sides. Like always, people always ask me this all the time, is a lot of work having a full-time academic role and also putting in work on the other end. But I think it's an important bridge to build, and I think the both worlds does benefit immensely from always coming together. Now, looking forward, universities have to look at the United Nations as partners in global norm making. Look at, obviously, like I do in my classrooms, embedding the UN engagement in curricula, and of course, strengthening advocacy for climate justice, gender equality, and human rights, and that can come from constant engagement with the UN mechanisms. And finally, bridging academia and the UN is not optional. It is essential for producing knowledge that transforms policy and empowers the next generation. And I did have another speaking engagement last week, and I did say to them that academia becomes a bridge when it translates knowledge into policy influence, transforms teaching into capacity building, and leverages UN engagement to ensure research impacts real-world advocacy. So we must connect our research to capacity building. We must connect our research to transforming our teaching, connect our research to bridging policy influence, and of course, ensure that real-world advocacy is also impacted. Thank you.
Thank you, Cynthia. That is absolutely fascinating and sounds incredibly fulfilling, if not exhausting. I would like to ask you, you've spoken about quite a wide range of areas, but I think something that might be of significant interest to the audience, you've spoken about active learning and passive learning. And how do you suggest that we sort of translate the kind of advocacy skills that you're talking about into the curriculum so that students of human rights start to learn and develop the skills that they are building?
I think, and this is one thing we discovered, I think the first step is training, because when we talk about the United Nations mechanism, is, like you said, it's a wide range of things. It could go from policy drafts to advocacy, it could go to diplomacy, is a whole wide range of things. So one thing we decided was the Advocacy and Social Action Development Program, like I said, is to train them. So the first step is to train them in those mechanisms, let them have the basic knowledge on how to apply both their knowledge, not just the ones being taught in the classroom, because then we can go into the classroom and with AI and everything going on, they can pick up that knowledge. So it's important that they also have lecturers that work in the field, because I think students are more inclined to believe what you're saying if you tell them you've been there. Because for some people looking in, it's United Nations seems like this something unattainable, something they could never reach. But if you say to them, oh, last week I just came back from Geneva and this is what we discussed, and you're putting the draft up on the screen, they are more interested in what you're saying. And then once, for instance, like when I was doing the international human rights class, and I had the references I had were the published written input from critical minerals by Special Rapporteur on climate change, and another one on Special Rapporteur on the rise of a healthy and sustainable environment. And those were my inputs, and then we could discuss them in real time. So I think it's a mixed, what we call a mixed, smart mix of measures. So bringing in that training, ensuring that more academics are engaged directly with the United Nations, and also making sure that the assessment setting also reflects what you're teaching, to make sure that you're getting the outcome that you deserve, or the outcome that you want.
And is the assessments that you undertake written, or do you do a holistic brand of assessments?
Holistic, I think that's the best, because I worked at a university where the written assessment was go home and do it for 6 hours, and then they give them a 6 hour. Anything can happen in 6 hours when nobody's being monitored. So I make sure it's a mixed methods presentation, 3,000 words draft in some cases, and they have a framework of the types of topics they can pick and where they can pick the topics from. And so that helps, stimulate that knowledge.
Well, thank you so much. That's been so interesting. I think really valuable for our audience. And thank you for coming and sharing your experiences with us. And over to you, Louise. Thank you.
Thank you so much, Cynthia. I hope you feel better soon. Thank you for joining us when you were unwell as well. Really appreciate that. It's my pleasure now to introduce Professor Dimitrios Giannolopoulos. He's the head of department academic programs at City St George's, University of London. Dimitrios most recently held the position of inaugural chair in law at Goldsmiths, and he's published widely on improperly obtained evidence, suspect rights, and the application of ECHR jurisprudence in domestic systems. Dimitrios was founder and director of the academic think tank Britain in Europe, and he led the Human Rights Awareness Programme, Knowing Our Rights, teaching over 3,000 students in local schools in London. He was elected an academic bencher at the Honourable Society of the Inner Temple in 2020. He joined Garden Court Chambers as an associate tenant in 2023, and he was also recently appointed as research visitor at the Bonnevero Institute of Human Rights at Oxford University. Dimitrios is going to talk to us today about countering disinformation and populist attacks on the ECHR at school and university and beyond the classroom. Over to you, Dimitrios. Thank you for joining us.
Thank you very much, Louise. My pleasure. Thanks for the very kind, most kind introduction. And I'm really sorry that I have missed a couple of the early presentations, but I had to attend to other work. So I will be discussing disinformation and populist attacks on the ECHR as the backdrop to then thinking actively, creatively about what we can do at the university in order to reinforce human rights education. So let me set the context first, which will be known, but does require reiteration, I would argue, in view of the current socio-political environment, the current political moment we were living through. So for over 15 years, the ECHR has been targeted by populist forces in the UK, its jurisprudence weaponized against moderate political parties and moderates within these parties, with the accusation being an alleged over-reliance on liberal democratic values, which undermines national sovereignty, parliamentary sovereignty, and the power of the state vis-à-vis that of the judiciary that allegedly overreaches. The court has been systematically scapegoated for advancing an absolute protection of rights in areas where it has very clearly taken a balanced approach, such as on prisoners' rights or the deportation of foreign national offenders. A report published this week by the Bonnevero Institute of Human Rights, which has reviewed 379 media reports where the ECHR has been applied in relation to immigration cases, has also brought to light misconceptions and often mischaracterizations about UK immigration law, the UK's appeal system, and the role played by the ECHR and the European Court of Human Rights in this context. So embedded in this political culture have such attacks, disinformation, and misinformation become that we, liberal academics, human rights scholars, activists, human rights lawyers, the judiciary, have learned to live with them, I would argue. We have never quite shaken off the embarrassment of being human rights and ECHR scholars in what was for a very long time the only country in Europe actively debating cancelling its human rights infrastructure and even withdrawing from the Council of Europe. Yet we had peculiarly somehow acclimatized to right-wing politicians maligning the operation and effect of the ECHR, perhaps trusting that the effect of their views would not extend beyond those residing at the extremities of the political spectrum. There were, of course, many commentators who sounded the alarm, especially when Brexit appeared as the catalyst which could precipitate what previously sounded unimaginable, a potential exit from the Council of Europe to follow soon after and coincide with exit from the EU. Now that the larger European entanglement has been successfully seen off, the time has come for finishing the unfinished business of human rights destruction, Conor Gertie was warning in the preface of On Fantasy Island shortly after the referendum. The opponents of human rights are feeling emboldened by Brexit, was writing Our Future and Our Present PM, Sir Keir Starmer, in 2017 at the European Human Rights Law Review. There are those that want Britain to retreat further from the obligations of internationalism, including from the Council of Europe and the European Convention on Human Rights. However, when the Brexit negotiations came and went, and ECHR attachment conditions followed as a precondition for security cooperation with the EU, even those alert to the continued damage that populist attacks upon the ECHR could ultimately inflict took pause for a moment and were reassured. The ECHR was at the eye of the storm at that moment. Brexit had not led to HRI repeal. Dominic Raab's plan to cause upheaval had failed. Sunak's Rwanda plan was crushed by the UK Supreme Court. A Labour victory was in the political horizon. A Labour victory happened. Everything was quiet in the eye of the storm. Then came Trump, and with him everything unraveled. Racism, xenophobia, the othering of vulnerable communities, and projecting sheer hate became routine, mainstream, channeled not just across the usual social media platforms, but also broadcast nationally and internationally, with White House press conferences and right-wing media in the US setting the rhythm, and Reform Party briefings and social media videos, and GB News report after report after report following suit in the UK, stirring division and polarization, and unleashing armies of angry men, and in some cases angry women, in the physical world and cyberspace. The conditions were, in other words, perfect for the re-emergence of the Farage phenomenon in the UK. And it is through him that the continuity from Brexit to ECHR withdrawal becomes crystal clear. We have moved from the eye of the storm to being hit by cyclone-level storms and heavy rain. We need to react, to anticipate and counter the attacks. Taking cover will not be enough, and that's the end of my metaphor here. We need active channels of communication on what the ECHR is, what it has done for us, what it can do for us in the future, what it would mean to lose it. Academia can, of course, only be a small part of this. There are greater forces at play here. It must, however, play its part. I will now take a few illustrations of how it can potentially do so, from the perspective of my practice and the practice of law schools, research institutes, and experts that I have the pleasure and privilege to be collaborating with. So first, I will speak to educating young people before they have even come to law school, and regardless of whether they may do so. 3/4 of all young people aged 16 to 24 are using social media services to access their news, according to the Ofcom 2025 report on news consumption in the UK. What the majority of this age group tend to be more interested in is lighter types of news compared to more serious news. But social media such as X are also being used by 12 to 15-year-olds for weightier news topics such as politics and current affairs. These are the same social media where extremism and anti-human rights narratives abound. So by the time students come to university, they will have often already been exposed to years and large volumes of fake news and disinformation on human rights and the ECHR not least. What can we as academics do to counter this phenomenon? Engagement with social media is the first illustration that I want to take of potentially engaging and confronting this issue. So we need to develop the capacity to use the same platforms ethically, but as effectively as those who actively push out fake news and disinformation. They do that work very effectively. We do not have the luxury, I would argue, to collectively abandon social media platforms as we have or seem to have done with X for good reason. But the result is that we are no longer there, and extremist narratives have run wild and dominated the platform. And our young people listen, perhaps not to X so much, but certainly social media platforms like TikTok and Instagram and YouTube. To take the latter as an example, let me point to a recent initiative by Dr. Alan Green at the University of Birmingham, who is building on YouTube a dedicated platform for legal education and research with the aim to provide clear, practical, and insightful content on legal writing and research with a focus on public law and human rights. A video on the truth about the UK leaving the HRLA has been viewed 175 times since publication a month ago, perhaps not that encouraging. A more recent one about why Angela Rayner resigned had 451 views since it was published 3 days ago. A promising start, but how can we channel more effectively the news, the knowledge, the expertise, the research that we have is the question that we need to ask. There is excellent public education content in many platforms run by academics. We can take Public Law for Everyone as an illustration by Cambridge Law's Professor Mark Elliott. But like most other academic platforms I note, it has not necessarily traveled very far or been tried in some of the more popular social media platforms that I mentioned a moment ago. Universities, including law schools for that matter, have not taken such efforts sufficiently seriously, I would argue. They do not feature in work allocation models. I know something about work allocation. I've been doing that for years. And academics tend to engage with them in their spare time, the little spare time that they have. If we are serious about public education, including in relation to human rights, we need universities to pay proper attention and plan. And I would say that the benefits will be manifold, including instrumentally from the viewpoint of effective investment of financial resource in the current environment, of course, in highlighting the law school's expertise in a particular area and its ability to speak to broader audiences. Schools outreach is a second illustration in this first area, which relates to engaging young people before they have even come to university. A second medium, therefore, is school outreach. I would say that universities are investing more time and human resource on reaching out and educating young students these days, with the key aim being to widen participation. Human rights education can be a powerful medium deployed in school outreach work. The right to privacy, sexual autonomy, freedom of expression, freedom of religion, the right to education, freedom from discrimination, the enjoyment of one's rights, and are ideas that our young people relate to and are anxious and enthusiastic to learn about. This reflects my own experience of engaging with young people in school workshops. I have taught 16 to 18-year-old students at school since 2017 as part of the Knowing Our Rights project that I set in motion that year, and which was very kindly mentioned by Louise at her introduction. This was funded by the Open Society Foundations. The funding not only covered for setting up a website and developing a brand or project identity, if you like, with a graphic design firm and covering travel expenses, but also allowed me, importantly, crucially, to join forces with a youth organization, Shout Out UK, who supported me with the organization and co-delivered with me human rights workshops in schools, across a number of schools, especially those outside London that I had much more limited capacity to deliver myself. In the first 2 years of the project, we reached more than 2,500 students across more than 40 schools in the UK, where we addressed what this HR is, how jurisprudence has impacted UK law, while also addressing conservative government plans to reform or repeal the Human Rights Act and potentially withdraw from the convention. The workshops were concluding with engaging students in debating for and against the HR. Students were then surveyed about whether we should stay in the HR. They were expressing overwhelming support for doing so. That was after a good 45 minutes or 60 minutes of exploring with them how this HR operates, what its impact has been upon UK law. We were also capturing the impact of the workshops by asking participants, student participants, whether they felt that they had more knowledge about human rights and the HR by the end of the workshop. Students were again overwhelmingly expressing the opinion that they were indeed more knowledgeable. Once the funded element, I think that's important, once the funded element was complete, I sought to embed the project in other school outreach initiatives in my former institution at Goldsmiths, such as summer schools, virtual workshops. Channel Talent is an organization I want to shout out to. They organize interactive school webinars for universities and proved a very effective platform for reaching out across a number of schools simultaneously. virtually. And we also provided knowing our rights work and information as contextual learning in existing modules in the curriculum at Goldsmiths. Let me now quickly move to discussing how we can support and embed human rights education in academic curricula and beyond the classroom. So that is the second area that I would like to focus on, human rights education at university and beyond the classroom. My key claim here is that there is much scope for curricular human rights education beyond the simple teaching of human rights modules in undergraduate and postgraduate programs, and that beyond the classroom activities in particular can also provide a backdrop against which to allow for calm, empathetic debate and reflection on the often highly politicized issues that surround the law of human rights, while also immersing students in the law in action. So first of all, a law in society, law in context approach. At the Department of Law at Goldsmiths, where I acted as, again, very kindly mentioned at the beginning, the inaugural chair in law for 7 years, inaugural head of department too, I had the unique opportunity to integrate contextual human rights and social justice teaching across a range of modules throughout the undergraduate degree and at postgraduate level too. So in year one, we were teaching public law in conjunction with the Human Rights Act. That's an approach that many law schools are taking these days. But we were also doing that in collaboration with eminent visiting professors, such as the former director of Liberty, Martha Spurer, Adam Wagner, KC, the founder of Rights Info, who's also well known for his outstanding public engagement work on this HR, or the former Attorney General, Dominic Grieve, who would take students on a breathtaking, I often found, nearly always found, trip through the Brexit years and their repercussions for life and constitutional practice at Westminster, populist politicians, and Brexit's continued impact on the HR debate. In year two, students would visit the Migration Museum as part of immigration law, sign up to undertake the Immigration Law and Policy Clinic, where they would work with an NGO actively engaged in asylum cases in Italy, and ultimately move to the Refugee Law Clinic at the University of London, where they would work under supervision on fresh claims in asylum cases. In year three, they would be similarly taught human rights law through an interactive human rights law and clinic-based module. They would apply to work as student journalists for leading human rights awareness platform Each Other, the former Rights Info, which we had embedded in the curriculum, while some of them would also get the opportunity to visit the European Court of Human Rights and the Council of Europe as part of our annual study trip there. A few illustrations only, and I should more broadly explain that we were adopting a contextual law and society approach, again in line with many law schools in the UK, across all our modules, including foundation legal knowledge modules, which was providing sufficient space to reflect on human rights and social justice, regardless of what subject area we were working on. So human rights and social justice were not simply knowledge we were aiming to pass on to students, but rather a mechanism, more importantly, a mechanism that was enabling us to deconstruct what law is, what law should be. As I explained, a range of law schools adopt this contextual approach. I think that's a very important and positive development in modern legal education in the UK. But the real distinctiveness in the program at Goldsmiths lied in the fact that the study visits and guest lectures and other immersive experiences were all fully embedded into each and every module and universally applied across the program, regardless of type of module or lecture personality. At the City Law School, where I have the privilege to now be the new head of the law program, the academic programs department, my new colleagues had similarly for some time worked on a law in context approach that starts in year one with two significant anchor modules, Foundations of Legal Analysis and Law in Practice. This will expose our students to a wealth of experience and expertise from across our academic team, providing analysis from a philosophical, economic, legal history, and legal cosmopolitan lens that again lends itself beautifully, I would argue, to integrating human rights and social justice learning and methods as interpretative tools. I'm thrilled that we're beginning to deliver these modules this academic year with a unique opportunity and the distinguishing factor compared to my previous experience at Goldsmiths, and now being the scalability of this approach, as we will be teaching hundreds of students across year one and the rest of the degree through the medium of the two modules that I mentioned. Final section, and I'm coming to conclusions very, very quickly, and I apologize if I have taken longer than I should have. Beyond the classroom, and the liberal arts approach to legal education is what I would argue the final mechanism here, at least as far as this presentation is concerned, the final illustration that I have the time to provide. And it's the final element in this human rights equation. I have run this approach. I have adopted this approach about 18 months ago and ran it for 18 months as head of the Department of Goldsmiths with demonstrable impact. And we do have ambitious plans to further extend the effect of such an approach across the diverse cohorts and multiplicity of programs that we have at City. The foundational principle of this approach that underpins this initiative is that the experience at university should be greater than the sum of its traditionally conceived academic parts and the knowledge communicated through lectures or seminars or the coursework and examinations that support its delivery. Experiencing the world, connecting with others, developing critical thinking skills, understanding how theory is applied in practice, exploring the plethora of interests that will make students well-rounded individuals, and ensuring students are enjoying themselves in the process of doing so, should matter, I argue, as much as the more formal aspects of the curriculum. Universities should be a world where students are continuously meeting inspirational people and going on life-shaping trips, where they're empowered to reflect on the past, engage with the present, and be part of the debates that have the capacity to forge the solutions that we need for the future. Students should be feeling fulfilled intellectually and emotionally by the sheer richness of the opportunities they are exposed to. Again, this approach lends itself perfectly to expanding students' horizons on human rights and social justice, visits to courts and other legal institutions and NGOs, attending public lectures and literary festivals, going to film screenings as a group, or watching live theater together, for example, at the National Theatre, something that we have done on a number of occasions in the recent past, exploring modern developments and historic approaches in museums and modern exhibition spaces. All of these activities can be a vehicle for human rights education beyond the classroom. It's not easily done, not least with the large cohorts law schools have to teach these days, but it is a program of activity that is scalable, and depending on location, cities is, for example, ideal for exploring legal, political, and cultural London. So with that, one can achieve great outcomes with moderate or proportionate financial and logistical investment. To conclude, considering current socio-political upheaval and how high the stakes are for social cohesion and safeguarding our liberal democratic values so that future generations will be able to continue to enjoy them, law schools and our universities more generally have a moral responsibility to harmonically embed engagement with human rights and social justice values, both within and outside the classroom. Thank you very much.
Thank you very much, Demetrios. Really appreciate that. Of course, you participated in an earlier event that I convened for Exeter Law School and HRLA and the IBA Human Rights Institute back in May with Baroness Kennedy. It was Human Rights in the Media, which touched on many of the issues of populism and polarization that you've brought up in your talk today. So, of course, media and information literacy very clearly being something that we need to better integrate into our human rights teaching. And you've talked already in your talk today about some of your work in this regard. I will post the link for the recording for that event in May, actually, into the chat shortly. We do have one question in the chat, but I'm afraid we are running a little late. So my apologies, Demetrios, but we are going to need to get to the next speaker. But I just want to say thank you very much for sharing your insights and being here with us today. I'm going to hand over to Fionn now. Thank you, Demetrios.